Adjournment request. Any other requests?
My lord, ma'am, the writ petition is fixed in the month of September, so I have filed an IA. Can it be listed next week, my lord? I have already filed.
Listed, sir. You asked the registry to list the IA. Why you are seeking permission for that?
For listing the IA, my lord.
They'll list. Once you have filed the IA, they'll list.
My lord, the writ petition is in the month of September.
Oh, that's why only you have this moved an IA for early listing.
IA in the writ petition, my lord.
For early listing of the.
No, my lord. We have come for with a separate prayer, my lord. We have a distinct prayer.
So that will be the registry will treat it separately and list it. Will direct them if any IA is there in a pending petition, the registry will list it. Where is the need of permission for that?
My lord, actually registered, they told me that we have to seek permission from your lord.
No, that's I'll clarify.
My lord, most of
Once the application is there, they have to list it.
Actually, they insisted that. I'm sorry.
Please clarify.
May I please, your lordship? My lord, I beg to mention for listing of a, my lord, writ petition, my lord, wherein the relevant provision of the service rule is challenged, my lord. My lord, can it be on Friday, my lord?
So you please move an application to the registry that and it will come before me as on administrator and give a date.
My lord. But some urgency is there, my lord. Selection is.
Mention that urgency.
My lord.
What's the problem in that?
Obliged, my lord.
May I please, your lordship? And I am also praying for listing of a writ petition pertaining to my lord, grade 1 post of judicial service of Mizoram, my lord. My lord, the first candidate has been, appointment has been cancelled. And as per law, my lord,
Move an application to the registry, the same thing. And show your urgency, I'll look into it and then pass.
actually the press advertisement has been issued, that's why.
Whatever the urgency, I mentioned an
We'll do that.
application before, registry will give a date. No problem.
We'll do that.
May it please, your lordship. Lordship, I beg to mention a writ appeal filed today, lordship, for a fresh admission tomorrow, lordship.
And please move an application to the registry, it will come before me, I'll take care of it.
Much obliged.
May I please, your lordship? Lordship, I am praying for adjournment of item number 6, lordship.
6.
Yes, sir. It's for admission, lordship. The senior counsel is unwell.
The request of the non-concept of the petitioner, this matter after 2 weeks.
Lordship. Obliged, lord.
Daily list for this item 1.
Steps have not been taken for.
Yes. Because once the period of contract comes to an end,
No, that step has not been taken. For the purpose of service of notice.
no, we have taken Dusty Miller. They are appeared also.
We have filed a wakalat number yesterday, my starting counsel. My lord, 2 weeks may be given for us to file a counter.
You are appearing for all the respondents?
No, only for the private respondents.
Private respondent, who is appearing for the government respondent or this?
There is only one respondent, the writ petitioner.
There was a discussion.
My lord, there was some urgency in this matter, my lord. Now the period of contract has come to an end. Now, once period of contract comes to an end, the contract doesn't survive for performance. End of the day, if the writ petition which is pending, if it is allowed, that will furnish him as a cause of action for my lord, suing for damages. But there is no scope of praying for performance of the contract once the period of contract has come to an
What
end.
the learned.
And my lord, no, my lord,
My
this,
lord, may,
What the
one
learned
second.
single judge has ordered?
no, my lord, what had happened in this case, we have issued a new tender in which he has not participated.
Okay,
Now, at his instance, the tender process has been stayed. We are against that staying order, my lord. We file an IA for vacating the order, and this learned single judge refused.
refuse to vacate the.
Yes.
my lord, that original writ petition judgment and order has not been appealed against them. They have complied with part of the order, but they don't want to give me 2 years. They have given me 6 months. My lord, may kindly give me 1 week. I'll come back to the court. I've just been briefed. I've not been.
Wednesday, next Wednesday.
Next Wednesday. Fine.
Okay, Mr. So-and-so put in appearance on behalf of all the respondent services therefore complete. Mr. Sharma, please some time to file counter to the writ appeal or what?
My lord,
Do you want to file a counter or what?
my lord, for a counter.
File a counter the writ petition, writ appeal. However, learned counsel for the appellant. has said that that he has submitted that he has sent urgency in the matter. List it on Wednesday, like date. List it on.
Obliged.
4-6. Item 2.
You are seeking intervention in respect of the promotion of this respondent number 1.
My lord.
My lord, we filed this appeal against the judgment passed by learned single judge, being the appellant. You have 4-5 appellants ultimately hearing the matter, and in terms of any promotion made will be subject to finding. In the meantime, one of the appellant number 1 has been promoted. So now they have filed an application for staying of this order. Now, my lord, this IA has been filed, I think, few days back. So at least we'll give a reply to it.
Okay, Mr. Das, put in appearance on behalf of,
The appellants.
for the appellants, in appeal number, writ appeal number 464/2023, he placed some time to file, title to the IA number 1574/2025. Time plate for is granted, but
No, after 2 weeks, my lord.
just after 2 weeks.
Briefly. Thank you very much.
For admission, item 3.
Pleases your lordship. My lord, appeal against the imping judgment dated 28/2/2024.
Demand for this is,
My lord,
on the ground that no opportunity.
My lord, only that please, my lord. Small.
On that, my lord, I respectfully submit that this is the type of the matter. There were other cases also were disposed of at the threshold. And in one of these cases, almost similar, giving no opportunity, just realization, unilateral order of recovery passed. And sitting in a division bench, your lordship endorses the view of the learned single. I am here to show that. So this is
That's
not.
all, but what's the problem in if liberty is granted to them to issue a fresh show cause notice?
Yes, my lord.
Or issue a show cause notice and then proceed in accordance with law?
Yes, my lord.
Lordship,
Here, the learned
After-
single judge has set aside the demand
No,
on
my
the
lord, after-
ground that no show cause notice was given to you. And he has closed the matter then and there. Now, what they are asking, at least they should have been granted in liberty to proceed further after giving a show cause notice to you.
that was the prayer, my lord, which is like allowing them to cure the built-in defect of their recovery.
That can't be.
And in other,
If the learned single judge has simply interfered with the order only on the ground that notice was not
Yes.
given to you before raising this demand, then what's the problem in granting them liberty to issue a fresh show cause notice in accordance with law and then proceed further?
the question is, my lord, it was done in respect of it after completion of 4 years after completion.
That is, you can very well raise your defense in the response
Reply.
to the show cause notice if any such issue.
4 years, but in all other cases, my lord, that was not done. The similar prayer was made.
That maybe they have not prayed for that. Here the appeal is only for that purpose. At least grant us liberty to proceed in accordance with law.
My lord, it is time barred for them now.
You raise this the objection.
This-
See, they'll consider it, and if they decide against you, come again. What's the wrong in that?
My lord, more
Once they have raised a demand, and that demand was set aside only on the ground that no opportunity was granted to you, let them grant you an opportunity and explain it.
In that case, my lord, let them refund the money which has been withheld, my lord, in spite of the protection given by. Money has been
where is
taken.
the cross appeal, my lord?
So that's another thing, sir.
Yes.
We
Let them-
simply, we propose to dispose of this petition while affirming the order of the learned single judge. Apart from, and only grant them an opportunity to proceed in accordance with law after issuing show cause notice.
I will agree to that. My lord, Lordship may come to the impugned judgment, last page, the operative portion here in this writ appeal, my lord. Let them do that, thereafter, let them give us notice. Page 199.
Yeah.
Of the judgment.
Yes.
This is absolutely same, my lord. Unilateral notice recovery
Yes,
after
that's right. Only this ground.
paragraph 16,
Yes.
119, my lord. Of the judgment impugned here, my lord. In the present case, decision of the respondent authorities to recover excess amount from the petitioner affects the right of petitioner along with civil consequence. Such recovery in law is required to be preceded by giving full opportunity to the petitioner. Absolutely same. So cause against such recovery. Admittedly, no notice was given. They also admitted. Therefore, there is gross violation of natural justice. In view of above, this court is of the considered view that the recovery notice is not issued in accordance with law and required to be interfered with. As such, recovery notice dated so and so issued by respondent is set aside and quashed with the observations made and directions given above. Writ petition stands allowed. Interim orders passed earlier is accordingly made absolute. Before the interim order, already money was taken away. Last sentence. It is further provided that security deposit, bank guarantee, and earnest money, if it is kept withheld, the same shall be released in accordance with law in terms of. Otherwise,
Will not interfere.
let them
with-
do this. Let them give a notice.
Sir, will not interfere with the order of the learned single judge, whatever the directions the learned single judge is granted, given, will affirm those directions. But simply giving them a liberty, if they want to, if they advise so and want to proceed further, they'll proceed further after issuing a show cause notice and after giving a full opportunity of hearing in accordance with law.
And the money, my lord, in spite of the court's order, Lanet Singh is
Then you file
that may be, my lord.
that is always open. Where is the question of observing that? That is always open. We are not.
No, they cannot have the cake and eat it too, my lord. They will withhold the money and then give me a notice. That means it will be. It will be a priori presumption that I owe them some money.
Yeah.
Am I clear, Lordship? Lordship will take care of that, then let them give me notice.
Let us.
Otherwise, now they cannot go to the civil court. It is time barred.
Because this writ appeal is preferred on behalf of preferred by the appellants in agree with the order dated 28/2/2024. It stop the only ground, the only effective ground taken in the appeal is that
Single judge already.
the learned single judges set aside the demand of rupees. How much demand was?
My lord, page 45.
Lord, it was 23,81,420.
Demand of rupees 23 lakhs,
81,420.
81,420 and 20 only on the ground that prior to raising such demand, no opportunity of hearing was granted to the to the sole respondent. It is sole respondent, however, the learned single judge has not granted any liberty to the appellants to proceed against the against the sole respondent after providing an opportunity of hearing to him in accordance with law. The facts of the case are that the respondents, what was your this contract or what was it?
My lord, that security deposit was withheld. Security
No,
deposit
it
and.
was a contract, na?
Yes, my lord, it was contract, my lord.
The
Contract, transport
facts of the
contract.
case are that the appellant and the appellants and the sole respondent entered into a contract.
Appointment letter is at page 43.
Just entered into a contract in respect of transportation of food grains or what?
Food grains, my lord.
Food grains. My lord, it is within the railhead, 0.75
Page-
kilometers from the
Food
way bridge to
grains-
this intersection.
food grains from the FCI go down to railway station.
Yes,
That's
my
a-
lord. Yes,
the
my
My
lord.
lord, it is FCI siding Bindukuri to FSD Bindu.
From one FCI is riding to the railway station.
FSD, my lord.
Yes,
To the FSD, food storage depot.
where?
My lord, at page 40, serial number 2, my lord. Page 40, serial number 2.
Store. Yes.
For transport to food grain from one destination to other, full stop. After the contract was over, the appellants has raised a demand of rupees 23,81,400 and 20 only. Full stop, agreed with the said demand. The sole respondent has approached the writ court, and the writ court has allowed the writ petition by the impugned order solely on the ground that before raising such demand, no show cause notice or opportunity of hearing was given to the respondent. Full stop. Having heard the learned counsel for the parties and after going through the impugned order, we are of the view that the learned single judge has not committed any illegality in setting aside the demand raised against the private respondent without providing any opportunity to it. Full stop. The learned single judges further ordered for releasing the security deposit, bank guarantee and earnest money if kept withheld to the respondent, to the sole respondent. Full stop. Having heard the learned counsel, sorry, we are of the view that though the learned single judges set aside the demand on the ground of demand because no opportunity of hearing was granted to the sole respondent, but the liberty should have been granted to the appellants to proceed against the respondent for realizing any demand, if any, after providing opportunity of hearing to him in accordance with law. Full stop. Hence, this writ appeal is disposed of. The impugned order passed by the learned single judge is affirmed. However, the respondents, however, the appellants shall be at liberty to proceed against the appellant after providing full fair opportunity of hearing to him in accordance with law. Full stop. The order passed by the learned single judge is affirmed with the above modifications. However, this order will not preclude the sole respondent to avail appropriate remedy.
Last paragraph of single judge.
Avail appropriate remedy available to it for compliance of the order passed by the learned single judge regarding the release of security deposit, bank guarantee and earnest money, etc.
My lord, Lordship, may I say, this is a huge amount. It is, my lord, in respect of completion, after 4 years of completion of the contract.
That is a matter of, that is a ground of defense.
So let them release this to me.
My lord,
That-
learned
that's a
single
big
judge has
deal.
not entered into
No,
the
please,
merit
let
of
them
the
release
case.
it to me.
Let him come.
Let them release this to me, and then otherwise it will be my lord.
We have kept it open.
Yes.
You can very well avail appropriate remedy for compliance of these directions, which has been given by the learned single judge in para number 19.
Para number 19. So let them accepting that, my lord, the lordship give opportunity. This may be made clear, my lord. That is my.
So we have already made clear in the order. You please read the order and yes.
Obliging.
Obligers.
Make peace, Lordship. Before my friend starts, Lordship, I'm appearing on behalf of Mr. R. Majumdar. He's on legs, my lord. Can this matter be taken up after some time, my lord? He just told me over the phone.
After a week.
My lord,
After a week.
off.
Yes.
Bless.
Item 5.
Notice returnable also and so.
My lord.
3 weeks returnable.
Obligation.
Item 7.
Yes, please, Your Lordship. My lord, the neighbor filed the complaint.
Do you have a copy of the judgment on which the learned single judge?
Yes, it's annex, my lord. Page 36. And the relevant portion is. Kya ki mana sile? There is judgment to. Judgment to kya hai? No, relevant portion ki hai. Kya hai? Main portion to तुमको ऐसे लगता है.
From page 71.
Yes. Under the State Act, the provision of appeal is not.
While allowing the writ petition, I sum up the conclusions as.
Yes, yes.
Yes.
Under the State Act, the provisions of appeal is not only confined to award compensation or levy of betterment fee. Appeal can be filed against any order of the authority. Against the stop construction order of the authority, an appeal lies to the appellate authority under the State Act. Appellate proceedings under the State Act are quasi-judicial in nature, and appellate authority exercises quasi-jurisdiction power. My lord, here the issue is slightly whatever. Section 13, subsection 5 of the Town and County Planning Act was not noticed, my lord. Just have a look, my lord.
In this judgment?
Yes.
And what about that division bench judgment there?
No, no, my lord, this judgment was relied upon.
But with the observation that has been affirmed by the division bench.
Yes.
Where is
Now,
that?
now please come to me, lord, subsection 5 of section 13 of this act.
The division bench has considered this.
Yes.
aspect
Division
and,
bench,
where is
This aspect was not considered.
no, this aspect was not considered, my lord.
the learned single judge has said that this has been affirmed?
No, 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 no. With all respect.
This is
No.
what the finding of the learned single judge.
Yeah.
Judgment was confirmed, but these aspects.
Para number 25 of the
Judgment in
appeal judgment.
yes, that is true, my lord. Judgment was confirmed, but this aspect was not gone into. Lordship will kindly have a look at subsection 5 of section 13, then everything will be clear. Subsection 5 of section 13. Restriction on use of land and buildings thereon after publication. Then please come to subsection 5. Notwithstanding anything contained in subsections 1 to 4 of this section, the subject matter covered under this section shall not be applicable in respect of residents inhabiting in the area notified as a municipality or a town committee under the provisions of the Assam Municipal Act 1956. All such matters relating to said areas shall be dealt with under section 171 of the said act. That means Guwahati Municipal Corporation Act. And in this case, my lord, which was dealt by the coordinate bench of the learned single judge, the permission of the stop construction order was issued by the town committee, not by the municipality. Here the permission is by the municipality. And lordship knows under the constitution also, if your lordship would kindly have Article 243W A2, it is the municipality. And the role of this development authorities are to, my lord, lay down the planning regulations. They are confined to planning. The building permission is under the, my lord, municipality. If your lordship would kindly come to Article 243W A2.
That the learned single judge had dealt with this argument in para number 41 of the judgment.
But, my lord, 13.5 was not noticed by the reported judgment, in the reported judgment. My lord. That's the whole difficulty. My lord, there was a stay order issued by the Ministry of Stop Construction. What, impelled them to file the appeal. We are saying this, let the municipal commissioner, my lord, take the issue to its logical end. We are not saying that, we are not assailing the order passed by the commissioner of the municipality, by the board. On what was the occasion to file the appeal? And that too an authority which has no jurisdiction. If you also to kindly have Article 243 WA, my lord.
Oh, in that case, before the learned single judge, the notice
Hmm.
was issued by the development authority.
Yes, here it is by the municipality.
But that's why only in the para number 41,
Yes.
the learned single judge has dealt with it and said, okay, no, the authority of the appellate authority cannot be confined only up to looking into this, what to say, award of, against the award of compensation against the levy of betterment fee. But it can also consider the notice of appeal against the
No,
notice
Lord,
of stop construction.
No, stop construction was given in their favor. Why they had gone to the appellate authority? There was already an order of stop construction by the municipality.
With what prayer they approached the appellate authority?
They went there with another prayer that the permission itself should be cancelled.
That has been cancelled.
No. No, my lord, my humble submission is, here the,
That in that appeal, what the appellate authority has done.
now appellate authority has now reiterated the order of stop construction. Now, my submission is, there is no occasion for this authority to intervene in this matter because there is no jurisdiction. Because subsection 5 of section 13 clearly says,
Notice. Returnable also. In the meantime, parties are directed to maintain status quo.
yes,
In respect of the construction of the building in question.
Item 8,
May it please your lordships. My lord, by the judgment and order, my lord, only on the ground that it
It's a
involves,
contract. It's a contract. Contract.
even though, even though, my lord, the learned single judge has decided that it involves the disputed facts, my lord. And that is the reason of.
Maybe, even though if it is not there.
My lord, for that one, I
In
am,
fact, yes, you are right that there is no bar in entertaining the petition in the contractual matters.
Yes.
But once the learned single judge has exercised his
My lord,
discretion,
that-
why the appellate court should interfere in
yes,
that?
my lord, the
It's a
finding,
reasonable one.
the finding arrived at by the learned single judge is absolutely not accordance with the law, my.
Erroneous.
Yes, my lord,
Which
for that
finding?
one,
Which finding did
yes, yes, my lord, for first at all, my lord, I am coming to page 49, my.
49.
49, your lordship will see.
Yeah.
That is the work order, my lord, as per this is second para, mode of payment. Monthly payment will be made to you for children according to progress of work and approved by the college construction committee. Next one, my lord, for purchase of imported electromechanical equipment, 70% of the cost of the equipment such and such bill be given in as advance after due approval of Colors Construction Committee. Now, my lord, your lordship will come to page 53, my lord. 53.
Yeah.
This is the letter addressed by the respondent number 3 to the education officer, my lord.
Yeah.
Second paragraph. There's a Demoria College was sanctioned an amount of rupees 1 crore only for construction swimming pool. While sanction letter such and such, out of which an amount of 50 was released. The construction work was awarded to the successful bidder, Brahmaputra Construction Complex, Guwahati, and who has executed about 70% of the work. The release amount of 50,000 has already been paid to Brahmaputra Construction, which has been submitted to your office on 2/7/16. That's sir, I would like to state that the remaining amount of 50 lakhs is released. Rupees 20,14,470 only will be paid to Brahmaputra Construction for work executed, and balance of rupees will be paid on completion of the work. My lord, my claim is only in respect of 20.
That's right.
Right, my lord. That is the admitted one. Now, my lord, next page, your lordship will come. That is the letter addressed to me at page 54, my lord.
Yes.
Second paragraph. We have already submitted the utilization certificate of the released amount of UGC narrow on yourself. If the remaining amount of 50 lakhs is released to Demoria College, the balance amount of 20,000, 20,40,400 will be paid to you, and rupees zeta will be paid after completion of the work. So, my lord, there is the admission. So far, the payment of 20
Whatever
lakhs.
it may be, sir, even though if it admission, if they are disputing,
Now,
that-
how, my lord, where is the scope of disputing? I am coming
Sir,
upon that one, my lord.
once they are disputing
I-
that, though, once they have determined that this much of amount is due, but thereafter they are disputing on whatever ground that you are not, this completed the construction or whatever it may be. It's a matter, it's a disputed question of fact.
No, my lord, on the basis of evidence they have given, they have not denied this aspect at all. That they are not bound to pay rupees 20 lakh.
Sir, we are
Well-
not inclined to interfere with the discretion exercised by the learned single judge. If there is an order which.
My
yes,
lord, in this
convey it is
particular one,
possible.
my lord.
It's a
whether-
plausible view, one of the view. We are not going to.
Yes, that is the view which has been taken.
There are some
But-
limitations of the jurisdiction of the writ appeals. And
But my lord,
in every case,
it-
it's not necessary that the
it-
court should interfere.
In support of it, my lord, first I told you, I am taking to your lordship to the judgment which has been referred by the learned single judge, my lord. Whether
Yes, sir.
2023 to SCC, page 703, my lord.
Just a minute.
Me-
Since airport. Or, this is something.
Page, my lord, at page 54, para 54, my lord.
There are 54.
Yes, my lord.
Yes.
54, my lord, 2. Let us come to 2.
Yes.
The principle laid down in such and such that in the cases of a non-administrative contract, the rights are governed only by the terms of contract and decisions which are purported to be followed, including such and such, may not continue to hold good in the light of what has been laid down in such and such, such and such, such. Next one, my lord. The mere fact that the relief is sought under a contract which is not statutory will not entitle the respondent state in case of itself to ward off security of his action or inaction under the contract. If the complaining party is able to establish that the action inaction is per se arbitrary. My lord, in this particular case, I have shown that it is per se arbitrary action which they have taken. And for that one, I have already taken to your lordship that they have admitted that this amount is to be paid. Now, my lord, your lordship will come The next one, after the contract is entered into, there can be variety of circumstances which may provide a cause of action to a party to a contract with the state to seek the relief by filing the writ petition. Accordingly, my lord, I have come. And now, fourth, without intending to be exhaustive, it may include the relief of seeking payment of amounts due to the aggrieved party from the state. The state can indeed be called upon to honor its obligations of making payment unless it be that there is a serious and genuine dispute. My lord, here is no serious and genuine dispute at all.
That is your case.
Yes, my lord, that I am showing from the record, my lord. I am satisfying your lordship from the record that it is not a uh, serious case, my lord. Because merely for the reason that I did not carry out the work further,
If you
that
have
can
to,
be
if you have to
reasoned,
go through the records for this, in your support your claim that you have no serious question, that itself is a disputed question. Until and unless there is a clear cut, yes, it is there, then, and that is also a discretion
Yes,
of
my
the
lord,
court. There is no
non-cons-
bar.
Ma-
There is no bar under Article 226 to interfere in the contractual matters, but
The-
once
the-
the learned single judge has exercised its discretion and has
Nay,
refused to, then why
discretion,
should
but
we go?
it must be judicially exercised, my lord. Now, my lord, the other judgment which I beg to refer regarding the disputed facts, my lord, that your lordship will see 2029 SCC, page 356, my lord.
20, volume 9, perhaps.
2029.
9, 356, my lord. Para 104, my lord. Para 104, my lord.
Airport authority. Is airport authority of India. Workshop. Exactly the airport authority of India is judgment, either it is respondent or respondent.
104, my lord. Para.
Yes.
Have you got it, my lord? The High Court is not deprived of its jurisdiction to entertain a petition under Article 226 merely because, in considering the petitioner's right to relief, questions of fact may fall to be determined. In a petition under Article 226, the High Court has jurisdiction to write issues both of fact and law. Exercise of jurisdiction is in its true discretionary, but the discretion must be exercised on sound judicial principles. Reference may be made inter alia to the judgment such and such. Now, having referred to the above decisions, it is obligatory on our part to refer to the two other authorities of this court, where it has been opined that under what circumstances disputed questions can be gone into. Such and such. The High Court observed that there will not determine disputed question of fact in a writ petition, but what facts were in dispute and what were admitted could only be determined after affidavit and reply was filed by the state. The High Court, however, proceeds to dispute the opinion remaining. The High Court is not deprived of its jurisdiction to entertain a petition under Article 226 merely because, in considering the petitioner's right to relief, questions of fact may fall to be determined. In a petition under Article 226, the High Court has jurisdiction to try issues, both of fact and law. Exercise of judiciary is, it is true, discretionary, but the discretion must be exercised on sound judicial principle. When the petitioner raises question of facts of a complex nature, which may, for their determination, require oral evidence to be taken, on that account, the High Court is of the view that this dispute may not appropriately be tried in a writ petition. In High Court may decline to try a petition. Rejection of a petition in limine will normally be justified where the High Court is of the view that it is frivolous because of the nature of the claim made disputed so to be agitated and the petition against the party against whom relief is claimed is not maintainable, or that the dispute raised thereby is such that it would be inappropriate to try in the jurisdiction for another. My lord, in this particular case, no oral evidence is required at all. Now, my lord, the next one. In the present case, in our judgment, the High Court was not justified in dismissing the petition on the grounds that it did not determine disputed question of fact. The High Court has jurisdiction to determine questions of fact, even if they are in dispute, and the present, in our judgment, is a case in which the interests of both the parties, the High Court should have entertained the petition and called for an affidavit reply from the respondent, and should have proceeded to try the petition instead of relegating the applicants to a separate suit. 105, my lord. Certain sir, therefore it is clear that the above enunciation of law, that merely because one of the parties to the litigation raises a dispute in regard to the facts of the case, the court entertains under Article of Constitution is not always bound to relegate the parties to a suit. In the above case assertion, this court even went to the extent of holding that in a writ petition, if the facts required, even oral evidence can be taken. This clearly shows that in an appropriate case, the writ court has the jurisdiction to enter a writ petition involving disputed questions of fact, and there is no absolute bar for entertaining a writ petition, even if the same arises out of a contractual obligation or involves some disputed question of fact. From the above discussion of ours, the following legal principle emerges as to the mandatory of writ petition. In an appropriate case, a writ petition, as against a say or instrumental issue arising out of contract, maintainable merely because some disputed question of fact arise for consideration, same cannot be found to refuse to entertain writ petition in all cases as a matter of rule. A writ petition involving consequential release of monetary claim is also maintainable. My lord, this being the position, my lord, and nowhere in the affidavit in opposition they deny that I did not, I am not entitled to 20 lakhs and odd amount, my lord, for the work done by me.
These two judgments are distinguishable. These two judgments of these first are distinguishable because here have been somehow disputed.
Yes, sir.
My lord, now I am taking to your lordship to the impugned judgment, madam. How this matter has been dealt with without considering the admission and other documents, my lord. That for that one, I am taking to your lordship page 87. There are 40. From the above, have you got it, my lord?
Yes.
From the above, it is seen that the contract is an instrumentality of recent petitioners, and from the proceedings of both the parties, it is also seen that the dispute is relatable to breach of contract. On the one hand, the petitioner asserts that he could not execute the part for the fault of the resident, particularly for 3 reasons: non-removal high tension electricity line above the proposed swimming pool. The respondents have failed to adhere to the condition of 70% advance against the imported electromechanical equipment, non-payment of remaining due. On the other hand, the respondent contains that they had already paid the running bill to the petitioner. The petitioner had abandoned the work and the authority has time removed the high tension electricity wire. My lord, so far this payment is concerned, they made the 50,000, no doubt. But for this particular purpose, my lord, first of all, I am saying to your lordship, to para at page 25, my lord, para 6. Para 6.
Yes.
That the petitioner begs to state that for the work completed, the petitioner submitted 4 running bills, the details of which are, and this has not been denied, my lord. The respondent has already made the payment of 50 lakhs. After repeated requests and reminders, in spite of specific condition of work order as well as the deed of agreement of making the payment to civil work according to progress of work and approved by the college construction committee. The respondent never adhered to the stipulated payment and still a sum of rupees 20,14,470 is lying outstanding payable to the petition for the work done. Such outstanding admitted as respondency in his letter number such and such address to the petitioner. Now, Shawan Mali. Begs to say is still prepared to carry on the remaining work, which had been stopped due to non-payment of dues of such and non-payment of such and such, being 70 electro, as well as inaction on the part of the national remove the high tension electricity line. The request for payment 70% cost and removal of high tension electric line, apart from being verbally made on many occasions, was subsequently so made by letter number 75, 2025. My lord, in letter to
This is
7.
what the bone of contention, this is what the dispute. You are saying, yeah, they have not removed the high tension line. They are saying we have already removed. This is what the.
Yes, my
dispute.
lord, I admit that
Where
they
is
have
that?
removed, but when they remove, after
That is
stoppage
the-
of work, my
Mr. T,
my
Mr.
lord,
Bhatt, please try to understand. That is the disputed question. You, though you are admitting that they removed, but they have removed after so and so time. They are saying, no, we have removed in time.
my lord, for this particular purpose, my lord, again I am taking to para 6, my lord. When I stop it, and that you also will find at page page 55, my lord.
Yes.
And this letter has not been denied by them, my lord. Page 55. This is the letter which I have written, my lord. We assure you to start the work. First, secondly, in the meeting, you gave the assurance you can pay us full 1 crore amount from other funds without depending on the grant or UGC. Our payment will not be delayed for the UGC fund. If we keep on working, you will make a interim payment and final payment as in the agreement. The respective grant letters, such and such, that is, please confirm your payment plan in writing as discussed in the meeting so the work can be completed without delay. Now, first, we need to purchase electronic item because it will take around 3 months and we have to pay it in advance. So please pay the advance of 70% of the amount of the electromechanical items. Estimated value is 14 lakh, 70% comes about 14 lakh. Now, please release the advance amount such and such immediately so that we can give orders to purchase those items. Release of payment of 70% is also mentioned in our agreement. We will start the work as soon as you release the fund. And also I request you to consider the damage incurred by us for delay in removing of the HC line work was stopped from 1/5/24 to the present day. The information of removal of HC college was given to us on 3/04/25. My lord, this fact is admitted on such and such date it was given, and we are ready to, provided this payment is made. So that, my lord, there cannot be any disputed facts which cannot be done into the writ petition, my lord.
That's all. That's all.
And apart from it, my lord, your lordship may see the affidavit, what they have in para 9 of their affidavit at page 64, my lord. That is 64, my lord, and that is not the correct position, my lord. Para 9 which has been relied on.
70%.
Yes,
Para 9, my lord.
yes.
That with regard to the para 5 of the petition, it is partly admitted that the work order was issued such and such principle observing all the formalities as such advertising form committee, and accordingly construction was started with briefing contract. The running bills were paid by the respondent according to the provision approved the custodian committee of the concern. A total had been paid by the answer for concern petitioner, my lord. This has been admitted, my lord, in para 6 of my petition, that 50 lakhs we issued. Apart from 50 lakhs, because we completed 70% of it, and that's why we are entitled to have remaining 20 lakh something, as well as the cost of the page 77, madam. It was removed on 2/4/2015, madam. So this being the position, madam, the alternative prayer in this particular what I am going to make out, that so far the civil suit is concerned, if I file the civil suit would be barred. Under
No,
the
you
law.
have to, then the bar is another thing. The only question is because you don't want to pay the court fees. This is what the question is. That's why only you approach the court. Otherwise, you have to, pay this.
In that case,
If it
So, my lord,
is
it is-
barred, then it is barred. It doesn't mean that once you wait for this limitation is over and then you approach the court case, since the bar is there, therefore now the court should interfere. This can't be.
no, because my
this is
lord, my
ideal
humble
luxury.
submission that
You
if
can't approach the courts as per
if your lordship
convenience.
is not inclined to issue any rule or admit it, in that case, my lord, a reasoned order may be kindly be
They are passing it. They're passing it.
referring the judgment which I have referred.
Yes, what do you want to say?
Milord, I am for the Investigation Commission. The judgment which was under challenge before this court, Milord, that paragraph 86 of the petition, the affidavit filed by the college concerned is quoted. It is clearly said that the work has not been completed.
Yes, that is the
If it is
admitted-
not completed, Milord,
When-
payments, how can it be made? And there is this.
Let him argue, sir. Let him argue.
So, Milord, Lord Singhesa has rightly, Milord, observed that these things are disputed and the writ court cannot go into this to find out who is correct or who is wrong. The payment of money from the government exchequers, Milord.
Yes. That's all. This inter-court appeal is filed by the appellant being agreed with the order dated 2/4/2025, passed in writ petition number 3575 of 2020, whereby the learned single judge has dismissed the writ petition filed by the appellant while granting liberty, while observing that the impugned order will not preclude the appellant to exercise and opt any other remedy available under the law for redressal of his grievance, and the order passed by the order shall not be treated as any comment on the claim or counterclaim of the contesting parties. Full stop. The brief facts of the case are that the appellant, being a contractor, was awarded a contract for the construction of swimming pool, including boundary wall, changing room, toilet, store, pump house, plumbing, landscaping, tiles fitting, boring, septic tank, overhead tank, waterproofing, earthwork, construction of 2 rooms, guest house. You get it quoted from
Yes,
this, get it quoted from para number 2 of the the impugned judgment. Full stop. The petitioner has claimed that though he has completed 70% of the work, and as per the same, he is entitled. He was entitled to get a payment of rupees 70 lakhs 14,473. But the respondent, which is that agency who has granted the contract?
Brahmaputra Construction.
Respondent number three.
Brahmaputra, but the respondent, Brahmaputra. No,
Brahmaputra
this-
Construction.
Who was the person who has granted this contract to him?
The principal,
Principal of respondent number three, my lord.
the principal remote.
But the respondent number 3 has failed to make payment of the remaining amount of rupees 20 lakh 14,407, had made the payment of rupees 50 lakhs.
Yes.
Though the respondent has, however, the respondent number 3 has made a payment of rupees 50 lakh. But the remaining amount has not been repaid. The remaining amount, that is 20 lakh 14,473, has not been paid despite repeated remarks, demands. Full stop. The respondents, the respondent college, as well as the state, has refuted the claim of the appellant while contending that the appellant has failed to complete the, has failed to execute the work, construction work allotted to it, and has abandoned the contract without any justifiable reason, and therefore he is not, the appellant is not entitled to get the payment of the amount of rupees 20 lakh 14,473. Full stop. The learned single judge, after taking into consideration the rival strengths of the parties, has dismissed the writ petition while observing as under para number 12 to this 18 of the impugned order. Learned counsel for the appellant assailing the impugned order has argued that it is settled that the in contractual matters where there is no serious dispute or disputed, there is no serious dispute, the writ court can interfere. And stop. Learned counsel for the appellant has placed reliance on decision of the Honorable Supreme Court rendered in this MP Power Management and so, and is another
This one is Rahi.
Hari Krishna
Hari
Mandir
Krishna.
Trust, what's the state of Maharashtra and others. Full stop. Learned counsel for the appellant has submitted that in the present case, no serious or disputed questions of fact arise, and therefore the learned single judge arise because the respondent number 3 and other authorities have accepted the claim of the appellant for payment of the remaining amount of rupees 20 lakh 14,473 while issuing certain communications and letters and the letters. Full stop. It is contended that in the above referred circumstances, the learned single judge ought to have exercised the writ jurisdiction and should have granted the relief to the appellant. Full stop. Per contra, learned counsel appearing for the respondent. You are appearing for?
University Grants Commission. Respondent 1 and 2.
Respondent number 1 and 2 has supported the impugned judgment as and has argued that the learned single judge has not committed any illegality in relegating, in not interfering in the matter because certain serious disputed questions of facts are involved in the matter, and the matter being a contractual matter, the petitioner, where their reliefs have rightly been refused to the appellant. Full stop. Heard Union Counsel for the parties and peruse the material available on record. There is no quarrel about the position of law that a writ court can interfere in a contractual matter. And there is no prohibition for the writ court to entertain a writ petition. Full stop. However, in the present case, the learned single judge has specifically taken into consideration the dispute. The specific taken into consideration the fact that on one hand, the appellant is claiming that he has already discharged. He has already executed the work assigned to him, and executed the work assigned to him, except around 30% of the work. But for that, only the respondent number 3 was responsible because the high tension line could not be removed within time. Full stop. The respondent number the respondent number 3, whereas the respondent number 3 is claiming that the high tension line was removed in time, but the appellant has failed to discharge, failed to complete the work assigned to it, and has abandoned the same. Full stop. The Honorable, the Honorable Supreme Court in Airport Authority of India, the Honorable Supreme Court in a recent judgment, Airport Authority of India versus Pradeep Kumar Banerjee, has dealt with the issue of intra-court jurisdiction to be exercised by the appellate court, and it has been held in para number 36 and 37. Stop. We are of the view that view that the learned single judge, while taking into consideration the facts and circumstances of the case, has refused to interfere in the, refused to give any relief, and the same is a plausible view which cannot be disturbed while exercising intra-court appeal. Hence, we don't find any merit in this appeal. The same is therefore dismissed.
No problem.
What about sir? Thank you.